matter of the King on the application of Gould and another and Devon County Council.
Yes, Mr. Broach.
My lords, my lady, I appear for the appellants, leading Ms. Leyden. My own friend Mr. Orban, King's Counsel, and Mr. Jackson appear for the respondent local authority.
Yes.
This appeal is against the order made by Mr. Justice Eyre on the 24th of January last, dismissing the appellant's claim for judicial review against the respondent's decision to close the North Devon Link Service. Your lordships, your ladyship will be aware that the appellants are two individuals with mental health needs who were users of the service. The first appellant attended the centre in Bidford and the second appellant attended the centre in Barnstaple. And the first appellant is in court today, my lords and ladies. This appeal principally concerns whether the closure decision was lawful where no regard was paid by members to the duties in sections 2, 3 or 5 of the Care Act when it was taken or to their substance. And as a preliminary point, the appellants submit that the consequences of this appeal being allowed would be modest. All that would be required in similar future cases, if this appeal succeeds, would be for members to be assisted to consider the matters set out in relevant statutory duties when decisions are taken to close services such as these. And we say that would not impose any kind of onerous or unduly difficult obligation on local authorities. There are two procedural points, my lords, my lady. First is the appellants yesterday filed a second supplementary bundle, which contains 4 of the witness statements which were before the High Court. They're all dated May 2024. They were all in the issue bundle with the claim form. We apologise that these were provided to this court so late. This was an oversight by the appellant's legal team. We say that in relation to ground 1, it's appropriate for this court to see the impact evidence from 4 additional service users. Mr. Mullane was the second claimant below. Mr. Quennell, Ms. Fors and Ms. Dark are former service users. 3 of the 4 statements are cited in either our statement of facts and grounds and or our skeleton below. That's Mr. Mullane, Mr. Quennell and Ms. Fors. And we say it's appropriate for the court to have the actual statements, not just those summaries, in order to consider the merits of our first ground, which concerns the judge's approach to the facts. The defendant has objected, and in so doing has improperly sought to adduce fresh evidence.
Improperly?
Yes, my lord. Because the defendant is not simply objecting to our late production of evidence that was before the judge. They've sent in genuine fresh evidence. Paragraph 5 of their letter of objection is effectively evidence as to what's happened in relation to the service users, and they filed
We're not allowed to know that, Mr. Broach.
Well, my lord, indeed. And they filed a document from November
Not
2025.
allowed to know that.
No. So we say that everything in that part of my friend's response ought to be discounted. It is entirely disputed what they say. My clients don't consider that anything said there is correct. But as your lordship said, it's nothing to do with this appeal.
So, right.
So we
this
invite...
is the latest response is untrue.
but irrelevant.
Right.
So, my lord, we said there's no real prejudice to the respondent. We do apologise that these statements are provided so late. They ought to have been provided when the appeal was filed. That is our fault. But we say the respondent isn't prejudiced. They've had these statements for almost 2 years. They've provided extensive evidence themselves before the judge dealing with our evidence. It is appropriate for the court to see what the witnesses were saying about the impact of these services on them in order to determine our ground one.
Right. You said you had two.
The second is less controversial, my lord. I hope not controversial at all. Merely extra authorities. So we filed two, which are Bowen and DSD. Bowen is relevant to ground one, DSD relevant to ground two, and my own friends have filed one, which is DB, relevant to ground one. Those have, I hope, have all reached your lordship and your ladyship.
We discussed, speaking of myself, the second point is not really an application.
No.
You have, as so many people do, used one or two extra authorities as well as the large volume of authorities which are already in the bundles. We need not say anything about that now. The first, however, is plainly much more contentious.
Yes, my lord.
We had discussed it beforehand, and our provisional view was that we might allow the material to be put in de bene esse for the non-Latin speakers. We'll look at it without accepting at this stage that it's relevant
Yes,
or
well.
significant. But that if we did, then the response would have to go in as well.
My lord, yes. We would object only to paragraph 5 of the letter of response. Paragraphs 1 to 4 of the letter of response are responsive to our application. Paragraph 5 is new evidence.
Right, and you say the new evidence is irrelevant?
Irrelevant and wrong, my lord.
And wrong, right.
And we did not want to trouble your lordships, your ladyship, with our response to why it's wrong, but it's, we say, most fundamentally irrelevant, because it's all about what the defendant says has happened since the decision.
Right, well, we better hear from Mr. Auburn then.
Thank you, Lord. We were hoping both parties wouldn't be taking time on this issue before we were obviously keen to get started on the substance of the appeal. You have our letter that was sent in to court on this issue, and we've made up on. We hear what your lordship say about accepting the evidence, but you know our concerns that this evidence isn't helpful to the actual appeal and is, if anything, a distraction from it.
Mr. Auburn, sorry, perhaps I'm getting old and deaf as well as old and grumpy, but
Yes.
you're talking down into your
I beg your
into your
pardon.
notes. My lord agrees.
Thank you.
Remember, we're up here.
Yes, thank you. So, 4 short points. Firstly, the purpose of the evidence. This appeal is concerned with identifying points of law, legal error, and the adducing of this new evidence, which we've had very recently, doesn't go to those points of law or legal error. And this hearing isn't a rehearing of the factual matters. That's the first point. The second point is one we noted in the letter, Mr. Justice Eyre's criticism of this witness evidence, which he made in paragraph 20 of his judgment, which was quoted, cited in the letter. I won't repeat that here, but he was concerned about the evidence of its nature. The third point, simply the lateness, and there isn't a good reason. All that's said is apologies given, and we've thought about it now, but there isn't actually a reason why this evidence is being adduced now at this late stage in this court. The fourth point, prejudice, which I do want to touch on, and prejudice, and including the contentious paragraph 5 of our letter. There is real prejudice in admitting this evidence at this point.
Sorry, which evidence?
The evidence, I beg your pardon, the 4 statements the appellants seek to now put in this court.
Even though it was before the judge below. This is not exactly a fresh, from the appellant's point of view, it's hardly a fresh evidence application.
The reason, and I'll be brief on this, but the reason we say it's prejudice is because the evidence goes to concerns about the replacement of the link service and what effect that would have. The point of our contentious paragraph 5, which my friend objects to, is we say that, well, if we'd known that this evidence was going to be an issue in this court, then we would have very relevant evidence to put before you, which is the contentious point, and that's outlined in our paragraph 5 of the letter, namely that what we have seen subsequently is that the replacement, the new service, is a great success, and the concerns that were expressed previously simply haven't borne fruition.
I have to say I'm a little confused. The evidence as to what has happened since the decision, I really question its relevance. evidence that was before the judge that presumably is being deployed in order for this court to understand what the judge did, seems to me to be in a potentially different category. Just in the same way that bundles might include skeleton arguments below. In fact, often do include witness statements as well. But there seems to be a different nature between what you put in paragraph 5 in the company document.
Well, I do take the point that it's of a different nature. The point we make is that if we'd known these evidence of this category was going to be an issue, going to be put for you, we would have sought to put forward evidence which we say shows the correct picture. Now, whether I accept that that may have been objected to. We haven't put forward the evidence other than attach one document, but we haven't sought to go away and generate evidence or witness and anything of that nature. So we haven't done that task. The point we make is that it's an objection, it's a reason to be cautious about the evidence that the appellants are now putting in at this very late stage. Because the danger with that is that it denies us the opportunity to at least attempt to convince you that you should have a balanced picture. Whether you might ultimately decide, thank you, we've seen your witness statement, which you drafted over the last couple of days, and we're not going to take that in. But we haven't even had that opportunity to try to convince you of that.
I don't understand this, but the evidence that was before the judge was the evidence before the judge. I don't see why, in the normal way, we shouldn't see evidence that the judge saw. Evidence of what's happened subsequently is of a entirely different order. I don't understand the link you're making.
Well, I completely accept your point. The evidence of a completely different nature. The only point we make, and the way we phrase it in the letter, is to prejudice of taking up this evidence now when it hasn't been part of this appeal for months, or before not being part of this appeal, or in skeleton arguments or so on, now to take it up so close to the hearing a day or two.
That must be prejudice in the sense that you are unable to deal with it for some reason. It can't be prejudice in the sense that you can't reply to it, because obviously it was before the judge and you didn't reply to it before the judge.
In the lower court, yes. What we're saying is that it's prejudice in the sense of denying us an opportunity to put before you material which you might accept or reject, but at least we would have the opportunity to try.
But this would be material in a completely different category.
Well, yeah, I entirely accept the evidence we would seek to put before you is of a different nature than it wasn't before the High Court. I accept that. That we make the point of prejudice to say that that's what we would have sought to do. We can't say that you would have accepted it or we would have made it, but that's what we would have sought to do.
But you are seeking to do it now.
Well, Lord, we have to indicate to you what we would try to do. So this letter obviously had to be written yesterday because that's when the material comes. So the best we can do in that time is to indicate to you what we would have done. And that's what we sought to do.
All right, should we retire? Retire, because we're going to spend the whole morning on this point.
Yes.
Mr. Broach, is there anything that you didn't say first time round?
My lord, there's lots I can say in reply, but I would simply say this: we would be quite content with your lordship's suggestion of it being admitted to Benayase.
Well, we certainly can't go further than that at this stage.
Well, if there was any question of not admitting it to Benayase, then there are points I'm afraid I need to respond to. And the short point, my lord, is that there is nothing in that evidence that we are going to seek to deploy by reference to the effect of the services closing, nor could there be, because it's dated May 2024. It's all evidence about what the concerns were around the time of the decision, and that's how it will be deployed consistently with the evidence that is already before the court.
Right, thank you. We'll retire to consider this.
All rise available.
Mr. Broach, we will allow your let me call it new material. It's probably not fresh evidence as such. We will look at it de bene esse. We're not at the moment. We are yet to be persuaded that it will assist us much, but we will, as we've said, allow you to refer to it. It is deplorably late. We may have something to say about that later. So far as the letter of response is concerned, paragraphs 1 to 4 are well made and we have read them. We think that Mr. Broach is right to say that paragraph 5 of the letter and the document attached are fresh evidence which are not relevant to the issues we have to decide and the judge had to decide as to the lawfulness of the decision taken in 2020. Right, let's get on.
Yes, so my Lord's Mayor, much obliged. I propose to address your Lordship's relationship first on the core factual background and the 3 Care Act duties that we rely on before turning to the grounds of appeal and then the respondent's notice points. The judge set out the factual background in paragraph 12 onwards of the judgment and correctly identified that much of it was uncontroversial in terms of the basic facts. We've summarised the factual background in our skeleton argument for this appeal from paragraph 5 onwards, which is at page 31 of the core bundle. The nature of the service is summarised at paragraph 12 of the judgment. Could we turn that up, please?
Paragraph
12. We have the judgment twice in the core bundle, once behind the order
Yes.
and then once the approved version. I'm not sure which your Lordship's relationship marked up. So I'll give paragraph numbers if I may.
yes, please.
So 12 starts the factual summary. And we see the service was set up in 1992, so it was a long-standing service designed to support adults with mental health difficulties who did not require specialist NHS care. There were facilities for social and leisure activities and educational opportunities. And by the time of the decision, there were 3 centres in operation, Bidford, Ilfracombe and Barnstaple, all providing a drop-in service, offering a range of positive activities and opportunities for social interaction, which are described in paragraph 12. And the judge, we submit respectfully, correctly noted that although there had been a reduced attendance, the reason for that was complex, and there may well have been others who would have wanted to use the service. Paragraph 13 of the judgment has the judge noting that the bald summary given above didn't reflect what the appellant said about the service's true value or the important role it plays in practice. But the judge did not set out the appellant's actual evidence in this regard, and so we do wish to take the court briefly to the primary evidence. And that's all, well, the first of those documents, of course, are in the first supplemental bundle. And first of all, we have Ms. Gould's own witness statement. Could we go there, please? It's page 3 of the first supplemental. Has the court had any opportunity to read Ms. Gould's statement?
Speaking for myself, I have read the judgment, the decision under attack, and 2 skeleton arguments. I have not gone beyond that.
Very good. So I'm just going to take, if I may, the court to the key passages in Ms. Gould's witness statement. She introduces herself, sorry if I skip past the chronology, introduces herself at paragraph 5. I won't read out paragraph 5 as it has a range of personal information in it. The court there has the context for who Ms. Gould is. She describes her mental health problems at paragraph 6 through to 8. And then at paragraph 9 says, apart from going to the Link Centre, my anxiety means that I'm not able to go anywhere else alone. I rarely leave the house at all, other than to go to the Link Centres. I will sometimes go for a drive on my own. I've recently started volunteering at the North Devon Food Bank, where she's supported by Mr. Craigie, a friend and local councillor, and Ms. Fors, another Link Centre user. And in parenthesis, my lords, my lady, both Mr. Craigie and Ms. Fors are in court today. Aside from the Link Centre, this is the only place outside of my own home where I feel comfortable enough to spend time. Paragraph 10 describes her relationship with her daughter, who provides significant support to her. And at the very end of that paragraph, Ms. Gould says, going to the Link Centre allows my daughter to have a break from caring for me, not least because when I'm there, she knows that I'm safe. Paragraph 11 describes the slow process of Ms. Gould being able to access the Link Centre after her referral 8 years previously, when she was in a very difficult position. There were initial outreach services. A member of staff would come to her house. They slowly built up trust at the end of the page. And then over the page, it took 2 years of taxi service before she was able to go herself. Paragraph 12, except during COVID, when the centres were shut, she's attended the Bidford Centre 3 times a week. She did have a trial period when it was first proposed the centres might close, where she tried to stay away to see if she could cope, but this led to serious self-harming. In paragraph 14, she describes what benefit she gets from the Link Centre, spending her time taking part in activities which they organise, socialising with other service users, and receiving one-to-one support from the staff. And at the end, she says, sometimes it's just a chance for me to cry, as I don't like to cry in front of other people. Paragraph 15 has more about the benefits of the service, emphasising it's the interaction with others that makes the activities meaningful for her, and saying in the penultimate line, I have no opportunities to meet other people. Paragraph 16 describes her experience of the COVID closures. And then paragraph 17 brings in an important concept for the purposes of this appeal, which is the concept of eligible needs. Now, in parenthesis there, my lords, my lady, we address the distinction between eligible and non-eligible needs under the Care Act in our skeleton argument at paragraph 9, which is page 34 of the court bundle. Put very shortly, eligible needs are those needs identified through an assessment, which attain the threshold set in the eligibility regulations. And those regulations focus on the extent to which the needs impact on the person's life. So where Ms. Gould says in paragraph 17 that she had her first social care assessment in 2023, and she was assessed by the council as having eligible needs in certain domains, those then become needs that the council was under a specific duty to meet. There was another category of need, develop and maintain family or other personal relationships, where she was held not to have eligible needs, and she says she strongly disagreed with that. But of course, just because needs aren't eligible doesn't mean they're not there. They've been identified, but held not to be of the necessary intensity, put shortly, to meet the eligibility threshold. So paragraph 18 then describes Ms Gould's benefits from going to the centre, helping her with all aspects of normal life, including both eligible and non-eligible needs. She describes the Link Centre in the middle of the paragraph as a lifeline, being able to meet up with people, take part in activities and receive one-to-one support with my needs helps to prevent my mental health and the needs I have because of my poor mental health from reaching crisis point. This, of course, is central to our case as to the relevance of Section 2 of the Care Act, the prevention and reduction duty.
What I'm trying to understand is, obviously all this is entirely understandable, but why is one person's experience of the service relevant, or what's being relevant in more general sense?
Yes.
But what is the issue which it goes to?
So, my lord, that precisely explains why we want your lordships, your ladyship, to see the key evidence that was before the judge, because what was put before the judge was not simply Ms Gould's experience. There were, we've given your lordships and ladyship 6 accounts.
What does it matter with the experience of 6 people?
That, my lord, is ground 2 of the appeal, essentially. Because we say, well, ground 1, of course, says the judge was wrong to apply the well-known F and Surrey summarised principles in terms of factual disputes in this particular context.
What is the factual dispute?
But we say there is none, my lord. What we say is there was a mixed picture of evidence before the judge, where the defendant put forward its case as to what the services were doing, the claimant and those around them put forward their case, and the judge wrongly applied F and Surrey to what we say was not a question of primary fact, and said, well, I'm going to go with the defendant's version of events. What the judge ought to have done was look at all of this evidence in the round in terms of then deciding whether or not the statutory duties that we rely on were mandatory relevant considerations. So that's why I need to show the court what the evidence was.
What was the dispute? I'm just not really understanding what the dispute was.
As to what the impact of the services was, what benefit it had for people. That's the essential issue that was between the parties below, and is still between the parties, my lord.
So
There's no
you
dispute.
say
Sorry,
no
lady.
factual dispute.
No dispute of, sorry, my lady.
Presumably on the basis that these are all valid perceptions.
Yes. To the extent there is a factual dispute, my lady, we do say that our client's evidence was the best evidence of that.
Well,
But we
okay.
we'll come back to that perhaps, but we distinguish between questions like how many centres were there? How long did they open for? How many staff did they employ? What were the qualifications of those staff? Those are all questions of primary fact. If the defendant tells the court there are 3 centres, the court accepts there are 3 centres unless we can prove that they're wrong. When you get to the question that we say was essentially an issue here, which is what did these centres mean for the people who used them? What benefit accrued from going there? That's not a question of primary fact, we say. That's a question of that's of evaluative judgment.
No.
And it's not a F and Surrey type case where the
We
court
must
simply
pause
accepts.
there, Mr. Briggs,
Yes, my
because
lord.
this is absolutely fundamental
Yes.
to the case. You say that the degree of impact
Yes.
of closure in this case is not a question of primary fact.
Yes, I do, my lord.
Where do you get that from?
Because it's a question that requires evaluative judgment. It's not a question that is objectively answered one way or the other. And then perhaps I can develop that by reference to the authorities when we get to the ground. But in a moment I was answering my lord, Justice Phillips' question about why are we going to the evidence. And the reason for that, my lord, is that we say that properly understood in terms of what the function of the court was, the role of the judge in this case, which is about the relevance of statutory duties, was to look at all the evidence, weigh it up and consider all of it, not simply accept everything the defendant says unless we could show that it couldn't possibly be right.
But what I can't quite grasp at the moment is what is it said that the basis that the defendant on which the defendant acted, which is being challenged.
Yes, my lord.
Being said that the defendant reached an incorrect factual conclusion about the use or impact of the.
No, my lord. The sole basis on this appeal on which we challenge the decision is failure of regard to what we say are the relevant statutory duties. We say that it was for the court to determine what the relevant statutory duties were. And when doing that, the court needed to look at all the evidence. If we did challenge, of course, the rationality of the decision making. Of course, on a rationality basis, the court looks at what the defendant has decided and decides whether that's a rational approach to the evidence. But that's not the point on appeal. The point on appeal is simply a question of whether mandatory relevant considerations have been taken into account. They haven't been. The question is whether they were mandatory.
So, can I understand that a bit?
Of course, my lady.
Both the alternative bases on which you say these duties should be taken into account are either that they are expressly or impliedly required by statute.
Impliedly required by statute.
Or they're so obviously material
Correct.
that it would be irrational.
That's right.
not to. How does the evidential point that we're talking about play into those
So,
either of those issues? Because one is pure statutory
Yes.
interpretation, and one is Wensbury
unreasonableness.
unreasonable.
So on the first, my lady, yes, we if I may say so, first of all, my lady, that's entirely correct as a typology of what we say. On the first, we say it's for the court, as a matter of statutory construction, to decide whether or not the duties are relevant, and if they are, we say they ought to be taken into account. And that's the approach with the.
But the evidence can't really be relevant to that.
It is, my lady, in the sense of what was a relevant statutory duty. So the court will need to look at the evidence to decide what the relevant statutory duties were.
Right.
Because otherwise, how can the court decide which duties needed to be taken into account? But perhaps, I mean, these are the points that I need to develop, my lords, my lady, and I will.
Okay, but I'm having difficulty
I understand.
in relation to, I think it's your ground too, really.
Yes. Well, I of course, I will come back to that with in much more thorough terms in a moment. The second point you asked, my lady, was, well, how about the alternative basis, obvious materiality? Well, we say there again that it's not necessary for the court to take the F and Surrey approach of assuming that everything the defendant says is right. If it's deciding whether a statutory duty is obviously material to the decision that's being taken, again, the court can look at all the evidence and decide whether the only rational conclusion open to the local authority is that these duties are obviously material.
Can I ask a slightly different question?
Yes, my lady.
Which is the local authority obviously would not have had this evidence in front of it when it was taking the decision. So another difficulty I have is it's all very well for the court to sit here with the benefit of all these witness statements and say, well, actually, but hasn't a local authority got to take a decision based on the information actually available to
Yes, my lady. These are all users of this service. These are all users of the services who were communicating with the people who work in the service. We say all of this information was either known to the local authority or readily available to them. I accept entirely, my lady, that if a completely new point came in by the time of a hearing and a claimant was saying, oh, well, that makes this duty obviously material, and it couldn't reasonably have been known, wasn't known to the local authority, that would be impermissible. But that's not this case. So, my lords, if I may just quickly, and I will emphasise quickly, return to the witness evidence. Though I was going to spend more time on this than any of the other statements. Paragraph 19, what it does in her case. 18. Paragraph 19, she has some eligible needs which get 4 hours of support, and that the Link Centre was providing a venue for that service. Again, showing that it's not possible to totally separate out eligible and non-eligible needs. Paragraph 21 explains why at its highest that support couldn't replace the Link Centre. And then perhaps I can just flag paragraph 25 to 29, which were Ms. Gould's concerns at the time as to what the impact of closure would be. And that's, of course, what the defendant knew or ought to have known. They'd asked her. If we then look at Ms. Jeffrey's statement, which is the following document, Ms. Jeffrey's, which is now the second appellant, of course, summarises her needs at paragraph 3, says at paragraph 4 that she was receiving 10 hours of one-to-one support from the respondent, we presume to meet eligible needs. Paragraph 7, she's been using the Barnstable service for around 10 years.
So I'm sorry, we're on Miss Jeffries.
Yes, my lady. Page 16 of this bundle. And I've got to paragraph 7, which is the key paragraph about the Link Centre and its benefits to her. She emphasises over the page at 17 the importance of speaking to other service users and getting one-to-one support from the start. She describes her very serious adverse childhood experiences and says being able to speak to them keeps my mental health steady and makes me feel happy. Paragraph 8 describes the experience of COVID closure, and paragraph 11 describes her concerns about what would happen if the centre's closed. And then we have the 4 statements in the second supplemental bundle, Lords and Ladies, so I'll now show how we propose to deploy those. Again, very briefly. First of all, Mr. Mullane, he was the second claimant initially, before his claim was discontinued. And the relevant paragraphs for our purposes are paragraphs 8 to 11, where he describes how he uses the Link Centre. In particular, I'd emphasise the final sentence of paragraph 9 on page 6. Being able to go to the Link Centre and speak with my peers and the staff stops my mental health from flaring up. Paragraph 10 describes the break from caring that gives his wife. And then paragraph 17, over 2 pages, says towards the middle of that paragraph, without that support, my mental health would decline and I may end up in crisis. We then have Ms. Ford's statement over 2 more pages. Another service user at Bifford. Here I would focus, if I may please, on paragraphs 10 through to 13. And in particular, the importance for individuals like Ms. Ford's of support to do something as simple as to make a cup of tea, which she's able to do because she has encouragement from the staff. Paragraph 13 over the page describes the benefit of the Link Centre, saying she hasn't had a mental health crisis for some years now, and I have the Link Centre to thank for that. Paragraphs 14 to 15 describe the impact of closure during the pandemic on her mental health. And then paragraph 22, over at page 16, describes her fears about the impact of closure, saying she really worries I could go back to that dark place. And over at page 20, sorry, but the bottom paragraph 23, having the support of the Link Centres on hand has helped my recovery massively to the point where I've recently started volunteering and getting back into work. He says over the page of 25 that the respondent has missed the point about the kind of benefit that accrues from the Link Centre. It's not about getting support from NHS mental health services. It's about the fact that the centre is what keeps her functioning. She describes that the users have chronic lifelong needs which need reliable, regular check-ins and prompting on our own terms, and with experienced staff and a chance to interact with our peers and do suitable activities in a safe space. And then paragraph 27 are her concerns about the impact on her if the centres close.
Couldn't similar things be said there about a number of local authority services? For instance, services of people delivering meals, or carers going in to care for people, or many other services which are provided where users could say, this service is vital to my mental health. These are the only people I see, the only chance I have to chat to people. If that service was withdrawn, I would be in great difficulties with my mental health. So services, even though they have nothing to do directly with mental health, and nevertheless can be said to be vital to those service users' mental health.
That may be so, my lord, but the distinction here is twofold. One, these centres were expressly set up to support people with mental health problems. They were funded by a Section 75 agreement with the NHS. So they were jointly, well, they were actually operated by the NHS, funded by the council, which again shows that they were directly linked to the individual's mental health. Secondly, as the evidence is showing, I hope, what's the unique benefit of these centres is that people with these very substantial difficulties, as your Lordship's ladyship will read, are able to come together in what Ms. Force describes as a safe space and benefit from social interaction, which none of the examples that your Lordship posited would offer. So we say yes, but there was a very particular benefit of these services that the judge ought to have taken into account. So that's Ms. Force, my lords, my lady. Then, we looked at Mr. Quennell. No, Mr. Quennell next. So he's at page 20. Again, similar pattern, paragraph 3 describes his complex mix of diagnoses and needs, or as. Paragraph 7 refers again to the Link Centre as a safe space where I can come and get support. I can also relax and talk to other people, discuss my problems, etc. Paragraph 13 says that on days when I don't attend the Link Centre, I already find it very hard to cope. And he describes at the end of that paragraph the days that he can go to the Link Centre as a lifesaver. And then paragraphs 19 to 20 on the impact of closure, including concerns as to suicidality. And then finally, Ms. Dark. Ms. Dark's needs are summarised in paragraph 3. Again, a complex mix, including physical health problems and significant mental health problems. Paragraph 6 describes the benefit of using the Link Centre. Saying I find I'm not anxious when I'm there, and at the end it really chills me out to go there. Paragraph 15 describes how the decision or the risk of closure had led to an increase in self-harming. And paragraph 17, without access to the Link Centre, my mental health would get worse. So my lords, my lady, pausing there, what the court has and what the judge had is 6 first-hand accounts from service users of the very real benefits that they obtained from being able to regularly attend these centres, which in our submission, obviously, were playing a role in preventing deterioration in their mental health. And that we say is very significant evidence, in particular in relation to our ground 2 and indeed our ground 3. I'll come back to that if I may. I'll develop those submissions now. Before we go to the grounds, could I then look at the Care Act duties that we contend to be relevant, which are in tab 7 of the authorities bundle at page 19. So we put the whole of the first part of the Care Act in, including section 1, the wellbeing duty. But the wellbeing duty isn't relevant here, we say, because it's very expressly hooked to individuals, as it says in the first sentence, in exercising a function under this part in the case of an individual. Where we start for our purposes is section 2, page 21. And section 2.1 states that a local authority must provide or arrange for the provision of services, facilities or resources, or take other steps which it considers will contribute towards preventing or delaying the development by adults in its area of needs for care and support. Pausing there, not eligible needs, all needs for care and support. The same at B by reference to carers, then reduce the needs for care and support of adults in its area at C, and then at D, the same in relation to carers. And then at subsection 2, in performing that duty, a local authority must have regard to the importance of identifying services, facilities and resources already available in the authority's area and the extent to which the authority could involve or make use of them in performing that duty, and then other matters which are not so germane to this case. That's the first of the duties that we say is relevant. We describe it in shorthand as the prevention and reduction duty.
Can we, maybe you'll deal with this at a better time, but one of, certainly a question I have is, the respondents make a lot of you saying or not saying that this duty has been breached. So
Yes, my lady.
let's take the most obvious. There are some have regard to.
Yes, there are.
Express have regard to duties in 2.2. And I think the judge said, and you're not challenging, as I understand it, that you weren't alleging a breach of those duties.
Yes, Maddie. We only alleged breaches of the duties. Well, sorry, not breaches. We alleged failure of regard to the duties as a whole, which of course includes subsection 2. The reason for that, my lady, is the decision of Mrs. Justice Lang as she was in DAT. And that's why I'm going to need to take, notwithstanding that it's a first instance decision, I'm going to need to take the court to DAT to explain why the case has been put the way it has. Subsection 2, importantly, is parasitic on subsection 1. It's not a freestanding obligation of regard. It's a duty to have regard in performing the subsection 1 duty. So we say that this was a case where the matters contained in section 2 as a whole felt to be taken into account by the local authority in making the decision. And I'm going to show you by reference to DAT, that's precisely the approach the judge took to both substantive duties and have regard duties.
Can you help me just so I understand how this argument works? Section 2.1 provides a clear duty. It must provide or arrange for provision of services,
Yes.
etc. Now, you don't allege that the local authority is in breach of that.
No.
So the local authority, we must take it, has arranged for the provision of services, etc., as it is obliged to do.
Yes.
And in 2, in doing that, which it has done on this hypothesis, it must have regard to. And again, because you don't allege a breach, it must be taken that it did have regard to. So as it has performed 2.1 and 2.2, presumably in relation to other matters,
Yes.
why is it relevant in any way? Because it has performed its duties.
Well, my lord, this is why
On your very case.
I need to show the court DAT, because that's I argued in DAT the duties have been breached, and Mr. Justice Lang said that's not the right question. The question is whether they've been considered. I need to explain that to your lordship. But what we say here is that decisions about closures of services, in our case, or funding cuts that were in the relevant area, so by reference to prevention, delaying and reducing needs, must be capable of being influenced by the existence of the duty. So the error, it's an error that is exactly the same, we say, as the error in DAT, was that when members took the decision to close these services or to cut the funding for these services, they did so without knowing that there was a duty in Section 2 of the Care Act to provide services that contribute towards preventing or delaying the development of the needs and reducing the needs. And that's the same error as Mrs. Justice Lang identified in DAT. And the reason that matters, we say, is because if they had known there was such a duty, they might have made a different decision. They might have thought, well, actually, these services do or might do some of these things. And therefore, we'd like to know more about what the impact is. We'd like you to go and ask the service users. We'd like you to get the evidence that we've put before the court. And that's the reason why there is an illegality in this decision. But I do need to show you DAT to make this submission good, Mother.
Yes, well, you can either do that now or when you've run through.
If I can just run through the
sections of
duties,
the
and
care
then I'll go straight to DAT. I think that's the next point I would propose to the court too. So the next duty we say was relevant and felt to be considered is Section 3. And that's page 23. 3.1, a local authority must exercise its function under this part with a view to ensuring the integration of care and support provision with health provision and health-related provision, where it considers this would achieve the 3 goals that are set out: promote well-being, contribute to the prevention or delay development of needs, improve the quality of care and support for adults. And again, at 2, care and support provision means provision to meet adults' needs for care and support, etc. Again, no reference to eligible needs, it's all needs. Health provision, provision of health services as part of the health service. Health-related provision, provision of services which may have an effect on the health of individuals but which are not health services. And that includes at subsection 5, housing for this purpose. So we say again, to the extent we need to, obviously material. members ought to have known before closing these integrated services that were being operated by the NHS but under local authority funding, that there is a duty in Section 3 of the Care Act to exercise their functions with a view to ensuring the integration of care and support with health and health-related provision. That doesn't mean we have to say, assuming that the AT is correct, that there's been a breach of Section 3. What matters is that it was a relevant duty that members ought to have been informed about. So that's Section 3. And just for the point on the Section 75 agreement, just for your Lordship's ladyship note, that's in the report at paragraph 2.3 on page 282, and we will look at the report. And then finally, we say Section 5 was relevant as well. Section 5 is the market shaping duty, a duty to promote the efficient and effective operation of a market and services for meeting care and support needs, with a view to ensuring 3 outcomes: variety of providers to choose from, variety of high quality services, sufficient information to make an informed decision. And then nothing in subsection 2 that's particularly relevant to this decision, we say, which are the matters to which the authority must have regard in performing that duty. So we turn to subsection 3, regard to the need to ensure sufficient services are available for meeting the needs for care and support. Note again, not just eligible needs. One more point over the page, 8, the references in subsection 7 to services for meeting needs includes a reference to services, facilities or resources, the purpose of which is to contribute towards preventing or delaying the development of those needs. So again, there's a very clear link back to the prevention duty in subsection 2.
So the reference to a market, that's
Yes.
not, so what is that talking about?
It's a range of services being provided by a range of providers, and we see that at A and B, my lord, in 1. So a variety of providers to choose from who taken together provide a variety of services, and that those are of high quality.
What does this section add to your case?
We say that the link centre services were part of that market of services. And so when deciding to close those services, Section 5 was a mandatory relevant consideration.
Market is where things are charged for, isn't it?
Not in this context, with respect, my lord. When we look, and we don't have the statutory guidance in court, I'm afraid, but the guidance under the statute makes clear that what this is talking about is a range of providers from a range of different types of provision, whether that be commercial, voluntary sector, statutory.
There's a cost to the local authority, although the individual
Precisely.
service user is not.
Although in some cases they will pay, because people can, of course, pay for their own care and support from the market as well, my lord. But it doesn't necessarily mean a commercial provider. It means a provider of any kind.
It's a strange use of the term market. I mean, I would be grateful for some assistance.
Yes, my lord, we will.
Here means something which doesn't usually mean.
Yes, well, I do understand entirely the question, and we will endeavour to get that assistance over the short adjournment, if I may. But it's certainly well understood in the sector as being a duty that relates to, as it says in the heading, promoting diversity and quality in the provision of services generally. And the shorthand of market shaping is used to refer to the local authority's commissioning function, that their job is to make sure that there are this range of high quality services available in the market. It's a market, I suppose, my lords, in the sense that individuals are supposed to have choice and control as to how their needs are met, and so they choose which provider. But I'll see if I can do better than that over the short adjournment. Just for completeness then, the statutory provisions that follow are those in relation to assessment and the duty to meet eligible needs. I don't need to turn those up for present purposes. They're there for your lordship's ladyship to refer to if necessary. Well, as a lady, before I get to the grounds, the only other document I wanted to go to was the actual report itself, and it might be sensible if I do that before turning into the legal argument. That is at 282 in the core bundle.
Yes.
So my lord very helpfully indicated that your lordship has read this report. I'll go to the key points in any event, of course.
Yes.
We do say paragraph 2.3 is helpful in terms of understanding, first of all, the base cost of the service, £485,000 a year, but also the fact that it's funded by the council and managed by the interested party who played no part in the proceedings, the relevant NHS trust. So it's an integrated service. The respondent owns the buildings. There was at that time no proposal to dispose of them. Paragraph 2.4, the statement of principle, the council is committed to supporting adults with mental health and wellbeing needs in the best way it can. Do this, they want to constantly review everything they do to make sure people are getting the best possible outcomes from the resources they have available, and that access is as equitable as possible for everyone across the county. And then a major theme of the respondent's case throughout has been what's said at 2.5. The recommendation within this report means that people with eligible needs, as defined within the Care Act, will continue to have their eligible needs met. So this is, of course, what members were told.
Is the underlining in the original?
It is. It's a hyperlink, my lord, to the statutory guidance, if I remember rightly. We'll just double check.
Thank you.
The statutory guidance. We did check that because, of course, we can't click on this version, but we have clicked on the original. So that's a hyperlink. So, my lords and ladies, then section 3 describes the change. So in 2022, National Community Mental Health Framework funding was used to establish the Devon Mental Health Alliance, DMHA. And that started work. As a result, local people in North Devon can now access mental health support services in ways they could not previously, access through GP practices and the wider primary care team. And then at 3.2, during the consultation in February 2023, service users of the Link Service described themselves as having severe mental health needs, or that their mental health needs are too complex to be managed in primary care, but not severe enough for secondary care. They reported that they felt the drop-ins were the only support available to them. And then at 3.3, importantly, while the council acknowledges the strength of feeling on this matter, the service is commissioned to meet social care needs. It is not commissioned to provide support for mental health needs that are too complex to be managed in primary care. And we say you can immediately see here the potential relevance of the prevention and reduction duty in section 2 and the integration duty in section 3. Members, we say, were not being given the full picture. 3.5 then sets out that what the Devon Mental Health Alliance was planning to do wasn't going to replicate the Link service, but they could provide drop-in sessions and one-to-one support. And over at 3.6, there's a new mental health multi-agency team that could offer support in the first instance and make referrals, and that's described as a virtual team across service boundaries. And that's an important part of the rationale. We see this at 3.7. These services were not available at the time the Link service started, and that forms an important part of the rationale for proposing the Link service closure. And then at the end of 3.7, it's reasonable to question, they say, sorry, I'll give the full sentence, with specific national funding provided to the NHS to develop community health and wellbeing support and the new model of multi-agency teams and links with primary care, it is reasonable to question whether council funding should be used to fund very similar services. Well, again, we say, yes, of course, it's reasonable to question that. But members, in answering that question, ought to have been told about the existence of these duties. 3.10 again comes back to the respondent's main theme. The recommendation does not affect people's rights to support under the Care Act. We would, of course, take issue with that if, in the broadest sense, but it's accepted that where it is identified that people have eligible care and support needs that require a character assessment, we will ensure one is carried out. In addition, all service users are entitled to request a care needs assessment. None of that's in dispute, but we say this is the point. We then have the options analysis and the scoring. We don't need to spend time on this. There's no, the rationality challenge isn't pursued. So we then move on to section 5, which summarises the consultation in 2023. And partly in answer to my lady's question, it's important, we say, to note what's said at 5.10, because we do say that officers were aware of at least the broad thrust of the points that my clients then and their witnesses made in the evidence to the court. The main themes gathered from the consultation were the Link Centre should remain open. They offer activities that are beneficial to support people's mental health and a safe place to go. If they're going to close, alternatives will be needed with trained and skilled staff. Existing pressure will be placed on other existing services. We could be more creative with the buildings or consolidate the centres. And then this is important, we say, concern about increased risk of suicidal crisis were expressed, But the North Devon Link Service is not a crisis service and is not commissioned to provide that support. Again, we say officers are not helping members here. That's not the point. The point is that there are duties in relation to prevention and reduction in needs and integration of services, which the link service, we say, definitely was, or at the very least might have been supporting the discharge of.
When you say it's not the point, why isn't it a valid point to say, well, this wasn't what the service was designed to do?
It's valid. What misses the point, we say, is that it's not a crisis service. Because the point is not that the link centres were supporting people who are in crisis. The point is that the link centres were helping stop people getting into crisis. And that's what they miss. The prevention, the preventative function.
But that's made, isn't that sufficiently apparent from this report?
Well, my lady, with respect, we say no, because if you look at the first sentence, the members have accurately identified that respondents expressed concern about increased risk of suicide or crisis, to which the answer is, well, this isn't a crisis service. But that misses the point. The point is that this service is helping stop people getting into crisis in the first place.
That's what it means. But that's what it means, isn't
No,
it? It's
respectfully, Lord, my
it's
Lord,
exactly,
no.
It's exactly what it means. It's saying if you remove this, there's a risk of crisis,
Yes, but
which means that what it's doing is stopping crisis.
what then the council go on to talk about, the officer's going to talk about, is if you are in crisis, there are things you can do. There's a dedicated 24/7 urgent mental health service, etc. No one was saying that the link service was a crisis service. The link service was a service for people with, we would say, significant mental health needs that was helping keep them well.
But that's exactly what this says, isn't it?
Respectfully, my lord, absolutely not. What is meant by not a crisis service is not a service which is designed to intervene with people who are in crisis. We agree that that's right, but it misses the point.
But surely these are points of which any councillor would be well aware.
My lord,
Of course, a drop-in centre helps people, particularly people with mental health issues.
that's right, my lord. I expect it must be right that the members would know that. What they don't necessarily know, and the judge made a positive finding on this, which isn't appealed, is that there are statutory duties in these areas. So part of my learned friend's case below was a reliance on the institutional knowledge of the members. They would be aware of their Care Act duties.
Yeah.
That was rejected by the judge, and we say correctly, and there's no appeal against that. So what the officers failed to do, and I'm setting up the big point, my lord, is tell the members that there were duties that would go to those exact points that we can assume that at least most of the councillors would know, that these drop-in services would help people with mental health needs stay well.
So you say that this recommendation paper is setting up an unlawful decision because it should have included additional material, with a paragraph each for Care Act, Section 2, Section 3, Section 5.
Yes, my lord, and I'll show you where it should have gone.
Right. And if it had, say, those 3 additional paragraphs, would it have been all right?
Yes, my lord, unless we could challenge it on a rationality basis.
You're coming to that. Yes.
When you say the judge rejected the argument that these councillors should be taken to be aware of their Care Act duties, can you easily point us to?
Yes, my lord, my lady, I can. It's the discussion about the relevance of the case of Hollow. So it's judgment paragraph 118. Heading is the defendant to be treated as having had regard to the duties. So it's 116 and in particular 118. And there's no cross appeal on that point. So this court is, we respectfully submit, should proceed on the basis that if we're right that they had to have regard to these duties, they didn't. So the only question is whether they had to have regard to them. Does that assist, my lady? If we go back to the report then. reached 5.10.
Yeah.
If we could then move on, so just for headings now, section 6, the strategic plan, that was relevant to one of the grounds, but that's not pursued, so I don't say anything about those documents. 7 was the financial considerations. We note that there's no issue taken with anything said in section 7. Section 8, my lord and my lady, legal considerations. That's the answer to my lord's question. That's where members ought to have been told that there were relevant Care Act duties that they might want to take into account in terms of deciding whether or not to float the services. And in fact, all that's said, as we see at 8.1, the lawful implications of the proposal have been considered and taken into account in the preparation of this report, which is, we say, respectfully meaningless. And then 8.2, legal challenges will always form part of any consultation that seeks views on proposals for change. This has been the case during the course of the public consultation. The defendant had to reconsult, my lords and ladies. And then again, the usual rubric, the recommendations within this report mean that people with eligible needs as defined within the Care Act will continue to have their eligible needs met. So members were obviously aware that they ought to tell, officers were obviously aware that they ought to tell members that there's such a thing as eligible needs and that we have a duty to meet them. So they were aware that some of the Care Act obligations ought to be brought to the attention of members, but we say where they fell into error was by not bringing sections 2, 3 and 5 to their attention. Essentially the other side of the story. So then we have section 9, environmental impact, nothing to say there. Section 10, equality considerations. There was a PSED ground, but that fell away when a further impact assessment was produced. Section 11, risk management, nothing to say there. And then section 12 is the summary. Obviously that's relevant. 12.1 to 12.3 recap the new funding and the new services that have been brought in since the Link Service launched. 12.4 refers to the financial challenge of the Council, meaning difficult decisions to cease services and funding must be considered. The starting point is to protect services that contribute to meeting our statutory duties. Again, we say these services did contribute towards the Council meeting their statutory duties. It's not the ones they're focusing on here. And then 12.5 is the recommendation to close and to assist those Care Act eligible service users in receipt of outreach enabling support to access alternative equivalent services and support to transition to alternative community support with the Devon Mental Health Alliance. And then just for completeness, my lords, my lady, we have the minutes of the actual decision over the page 294. This issue starts at the very bottom of 295. The discussion goes over to 298. In our submission, there's nothing here that adds anything to what's said in the report. I'm sure my learned friends will point out anything they wish to, but there's no debate, there's no discussion, certainly of anything relevant to any of the duties we rely on in those sections of the minutes. So that's the relevant law and the relevant facts, my lords, my lady. Could I then pick up ground 1? And in particular, our skeleton argument, paragraph 22. What we say is the judge here erred by applying the well-established approach to the resolution of disputes of objective fact to matters which concern the effect of the services and their benefit for users. And we say that this wasn't a case where the judge needed to resolve any dispute of fact. We didn't invite him to. The appropriate course was to identify the full spectrum of evidence as to the impact of the services and then decide whether the claimants were correct as to the need for regard to be paid to the Care Act duties in the light of all the evidence. There's no dispute that in relation to objective facts, the approach as summarised by Mr. Justice Chamberlain in F and Surrey paragraph 50 is correct. And it may be helpful just to briefly turn that up as it's agreed to be a helpful summary of the law to date. That's page 783 of the authorities at tab 33, and paragraph 50 is at 791 of the authorities. And we say it's helpful to note at 791 at the outset that the heading here is the proper approach to the factual dispute about what the claimant's mother was told. So that's clearly an objective fact. Paragraph 46 starts with the obvious point, the one-note proposition, that in general courts hearing judicial review claims do not resolve disputes about primary fact. And then at 47, where a claimant invites the court to resolve a dispute of fact, various comments follow. And then we have the summary at paragraph 50, both parties rely on. The correct approach is as follows. A, if invited to resolve a dispute of primary fact, the court should consider carefully whether any pleaded ground of challenge really requires resolution of the dispute. In most cases, the answer will be that the resolution of the dispute was for the decision maker, not the court. The court's supervisory function does not require it to step into the shoes of the decision maker, etc. And then B, usually proceeds on written evidence where it is required. C, no absolute rule, the court must accept in full every part of the statement, and that's the cannot be correct proposition from Sophia. And then in D, if you can't resolve the written evidence, you'll proceed on the basis the fact hasn't been proved. That will be to the disadvantage of whichever party asserts it, generally the claimant. And that's the principle at the end. The defendant's evidence is to be preferred, save where it cannot be correct. Now, none of that's an issue. But the key point we say is the first one. It's unusual for the Judicial Review Court to be required to resolve a dispute of primary fact, and that the relevant issues here were not questions of objective fact and not ones that needed to be resolved. And that's where we turn to the case of Bowen, which is one of the two cases we've sent in late, which I apologise. This is the case of Bowen and the Secretary of State for Justice in terms of release on licence. And the relevant passage here is at paragraph 64, if I could ask the court to turn that up. Start at 62, if I may, at the bottom of page 2186 of the report. Focusing on the approach on appeal, looking to review the judge's decision, not a rehearing of the case. Again, none of that is contentious, but we rely in particular on the citation from the Assicurazioni case, where Lord Justice Clark, and that's paragraph 64 of this judgment, citing paragraph 16 of Lord Justice Clark. Some conclusions of fact are, however, not conclusions of primary fact of the kind to which I've just referred. They involve an assessment of a number of different factors which have to be weighed against each other. This is sometimes called an evaluation of the facts. It's often a matter of degree upon which different judges can legitimately differ. Such cases may be closely analogous to the exercise of a discretion. And that's the point we make, that there is a difference between the kinds of facts that I described as objectively provable, as in how many hours a week does the centre open, and the question of the impact of the service on the users, which is one that is much more akin to an evaluative judgment. And the
But surely this very well-known passage from Assicurazioni case is about the approach of an appellate court
Yes,
to findings by a trial judge.
it is, but
Not
it's,
an approach by an admin court judge to matters of evidence.
that's right, my lord. But the distinction that's drawn between matters of objective fact or primary fact and the kinds of evaluative judgments that Lord Justice Clark is referring to, we say is relevant here as well. The further learning that we draw from here is that what's said by, again, well known, I'm sure, what was said in Smet Properties. Well, Lord Justice Sales, this is at 71 in this judgment, citing Lord Justice Sales as he was in Smet Properties. Again, talking about appeals, but making the point, and we say this is highly relevant on this appeal between A and B, the weight to be given to the judge's own assessment will vary depending on the circumstances of each particular case, the nature of the finding or factual assessment which has been made, and the nature and range of evidential materials bearing upon it. So context is everything, we say.
Mm-hmm.
Now, if we go then to what the judge did in this case and look at paragraphs 21 to 27 in the judgment, we can see how we say the judge fell into error. So 21, the judge identified that the core of the claimant's evidence related to their needs and those of other service users and to the role performed by the service. They said that many of the users have complex mental health needs and so on. And they say, and this is almost a direct quote, if we look in the middle of the paragraph, that the service, regardless of the intention when it was created, it now operates as a lifeline for users who have real mental health difficulties. In practice, it operates to prevent those users from going into crisis. As such, it performs an important role in reducing the risk of suicide or self-harm. There's then at paragraph 22 reference to the fact that it was the defendant's evidence that had generated much of the heat in the competing evidence, in that she'd criticised the claimants, in particular the first claimant, for overstating the severity of her needs and her behaviour. 23, judge found that no deliberate exaggeration had been established, and then said it's understandable that service users with mental health problems will be very conscious of the impact which these problems have on their lives. Their perception of that impact is genuine, but it cannot be conclusive, and is inevitably not a detached or objective assessment of that impact. It's also understandable the defendant has a wider field of vision or will be aware of others with more serious problems. That wider perspective does, however, mean that the defendant is at risk of minimising the impact of the service users' problems on their daily lives. Now, we don't criticise either side of that analysis, my lords, my lady. What we say in relation to that is that that's precisely why this was not a dispute of fact case that ought to have been resolved on F&Surrey principles. What the judge ought to have done instead was consider both sides of the evidence in deciding the statutory duty question, as distinct from any irrationality challenge, which I accept would proceed on the basis of whether the defendant's own understanding of the facts was irrational.
At the moment, I'm not entirely sure what the dispute was at all.
Well, my lord, this is what we'll come to. 26.
Or should I just ask my question
I'm
first?
sorry, my lord.
As I understand it, as the judge said at 12, factual background uncontroversial. It was designed to support, to provide support and guidance to adults with mental health difficulties.
Yes.
That did not require specialist NHS care.
Yes, my lord.
And then the nature of the form the support took is set out, and I understand that's not controversial.
Correct.
Now, those, as it were, are the facts.
That's right.
Certainly, from the defendant's point of view, it's to provide support and guidance to adults with mental health difficulties.
That's right, my lord.
What is then said? Well, what is the effect, as it were, that has for persons with mental health difficulties? Now, it's inherent in what the defendant says that it would have a benefit to persons with mentally health difficulties because that's the purpose that they're providing it. And there's evidence from those persons as to A, what the benefit is, and B, what the detriment would be if it was withdrawn.
That's right, my lord.
I'm not sure what the dispute is at that point.
So my lord, that's what paragraph 28 is about. May I say, first of all, my lord, that I respectfully agree with everything your lordship has said, and we say that's going to be good enough to win this case. But we did, of course, say more than that. We said at paragraph 20, as the judge rightly summarised at paragraph 28, in the middle of the paragraph, we contended that although the service was created to provide social and related support, it operated in practice to prevent users falling into crisis and played a significant role in reducing the risk of self-harm and suicide. And this is where the error comes in, we say. Because the judge has then applied F&Surrey to say, well, that's a factual point. And if you want to say that, claimants, you need to meet the F&Surrey threshold of showing that the defendant's understanding cannot be right. And we say that's wrong. What the judge ought to have done instead is look at the evidence in the totality and say, well, the defendant doesn't accept the severity of the needs, doesn't accept the extent of the benefit, but what the service users are saying is that this has a real benefit to them and stops them going into crisis.
Forgive me, just try to understand this. In the middle of 28, it says the claimants assert that the defendant's understanding was mistaken.
Yes.
Now, what is that understanding which you were critical? Where do we find?
So that's in Ms. Forster's evidence, my lord, which I haven't taken the court to.
Surely it's got to be in the report, isn't it?
Well,
That's what we're looking at.
My lord, the judge here is comparing the evidence of Ms Forster, as we see, with the evidence of the claimants. I agree that the much more relevant document is the report.
Do you say that there is any misunderstanding in the report as to the function of the service?
My lord, 5.10, as we've canvassed, misunderstands what the consultees were telling the defendant in terms of the benefit of the service being stopping people from going into.
No, it's the function of the service.
Well, my lord, what we relied on was the effect of the service, and that's what we say makes these statutory duties relevant. Was what effect?
Obviously, we've got a lot of different words being used here, and the word in your skeleton. Sometimes it's the role of the service, sometimes it's the function of the service, sometimes it's the nature of the service. What are we talking about here? I mean, it seems to me that there is the fact of what is actually being provided, and then there is the purpose, the intended purpose for which it was provided. It seems to be that those are the only two factors, aren't they?
My lord, respectfully, we say no. The third relevant factor is what we would describe as the effect or the benefit. What is it actually doing in practice?
But you can't expect local authority to look at every single effect, the subjective effect experienced by each and every user. That would be an unworkable requirement. You've got to look at what is the intention as to what this is providing for the users as a whole.
Yes.
Not look at 6 different examples and see the way that 6 different people explain how it's benefiting them. That's just a completely unworkable analysis.
My lord, this isn't a suggestion that there was any individual assessment requirement. Absolutely not. We do agree that the defendant was entitled to look at it in the round, but we say that what the defendant couldn't do in the context, and I keep coming back to this point, that this is a case about regard to statutory duties. That when the defendant's part of its case is we don't need to have regard to the statutory duties.
Before we come back to that, at the moment,
Yes.
we're just talking about the defendant's understanding.
My lord, yes, but we're talking about the judge's understanding.
Well, as I say, you're saying your public law challenge is that the defendants misunderstood the nature of or the function of the service.
My lord, respectfully, no. My public law challenge is that the defendant has failed to have regard to these statutory duties. Why this is relevant is...
You don't say they misunderstood the service.
Not as a standalone ground, my lord, no. The reason that we are here on ground one challenging the judge's approach to the fact, and this is an appeal against what the judge did, of course, is the judge says, I'm not going to look at what the claimants say about the effect of these services because they failed to discharge the burden in F and Surrey, as we see at the bottom of paragraph 28. Their perception and belief, real and genuine though they are, don't establish the F and Surrey proposition. And then he says, I am to proceed on the basis that the defendant's understanding of the role and function of the service was correct. And that's the error, we say. Because in terms of understanding whether the statutory duties were relevant, you ought simply to have looked at all the evidence in the round.
But was he wrong to say, and I'm not sure that I see how he was wrong to say, that what actually mattered was the defendant's understanding or when you look at what the defendant was actually doing and what its role and function was intended to be, and that the different evidence of the claimants as to how that benefited them can't possibly have been a factor in that analysis.
It was wrong in this particular context, my lord. It's not wrong in a rationality context. I entirely accept that. But in the context of deciding whether or not the defendant has erred in law by failing to have regard to statutory duties, what the court ought to have done was look at all the evidence in the round. There was no factual dispute that needed to be resolved.
But I'm not sure. If you're right that the report should have but did not make express reference to sections 2, 3 and 5,
Yes.
why does anybody's witness statement matter?
Because
there's not a case where something was said at the meeting which makes a difference. So you say that the report failed to draw the attention of councillors to their statutory duties. But I don't, you may be right about that, you may be wrong about that. Why do witness statements as to the actual impact or potential impact of the closure of the service make any difference?
Because the judge had to decide which statutory duties were relevant. And in deciding which statutory duties were relevant, he ought to have looked at the totality of the evidence.
Isn't it all covered by the fact that it's designed to provide support and guidance to adults with mental health difficulties?
My lord, respectfully, yes, we say that is good enough because the prevention duty would be entirely triggered, we say, by that. It may be that that's right, and therefore ground one doesn't need to be resolved. But if we're wrong that section 2 at least was engaged and needed to be brought to the attention of members on the judge's analysis of the facts, then that's why we've said that he got the approach wrong and that he ought to have looked at all the evidence. So to put the point in summary, if I may, my lords, my lady, our case is that the judge ought not to have discarded the claimant's impact evidence on the basis of the principles in F and Surrey for the purposes of determining whether the statutory duties relied upon were relevant considerations, mandatory relevant considerations for the members making the decision. And that is all I propose to say about ground one, unless I can assist further.
Right.
So ground two then, DAT. So this is paragraph 33 of our skeleton. And we say, first of all, that the judge was right to hold that statutory duties such as those relied on by the appellants can in principle be mandatory relevant considerations. That's the judgment of paragraph 94. Where the judge erred, we say, was not to recognise that the approach of Mr. Justice Lane, as she was in DAT, assists in understanding when that will happen. We need to see the passages in DAT in context. They're set out in our skeleton of paragraphs 19 to 20. So can we turn up to tab 16 of the authorities? Page 229 of the authorities. And we see that this was a case concerning, from paragraph 1, a decision to cut funding to voluntary sector organisations who were providing short breaks to disabled children. So the factual context had similarities. At paragraph 5, the judge defined the main legal questions, and it's the first that's relevant in our case. Did the council err in its decisions in failing, 1, to ask itself the right questions, and or 2, to take into account mandatory relevant considerations? That is, the questions posed by and or the requirements of the statutory provisions which apply to short breaks. That's how the judge described it. I'll refer to this issue as the legality issue. So that's the judge's summary of the legality issue.
I note helpfully that this is one of your war stories, so you can answer this question.
Yes,
were the 3 questions set out in paragraph 5 agreed between counsel and given to the judge, or did she devise them for herself?
Yeah, very much hers, my lord, certainly this one. And the reason I can say that with confidence is that my case before the judge was that this local authority was in breach of all the relevant duties.
Yes.
And it was the judge who said, well, that's not the right question.
Right.
So the facts, we say, don't need to detain this court. What does assist in terms of understanding where the judge came into matters is paragraph 20 at 234. The judge said the first point is that there is no reference in this material to the terms of any of the legal provisions on which the claimants rely, or in a literal way, to the questions which those provisions did or might pose for a council which was considering cuts through its provision of short breaks. And we say our position is directly analogous to that. So what then were the relevant provisions? Well, they're set out from paragraph 24 onwards. So section 17, the general duty to children in need, is then linked to paragraph 6 of schedule 2 to the Children Act 1989, And that imposes a duty on every local authority to provide services designed, C, to assist individuals who provide care to continue to do so or to do so more effectively by giving them breaks from caring. So that was the headline short breaks duty. That duty must be performed in accordance with the regulations, the 2011 regulations. Those were then set out at 26, and in particular, Regulation 3 is a have regard duty that arises in performance of the overall short breaks duty, various needs that the local authority has to have regard to. But importantly for our purposes, Regulation 4, over the page at paragraph 27, is not a have regard duty. Regulation 4 is a substantive duty, and much more akin, we say, to sections 2 and 5 here. In performing their duty under paragraph 61C, a local authority must provide, so far as is reasonably practicable, a range of services which is sufficient to assist carers to continue to provide care or to do so more effectively. And then, in particular, there are 4 subtypes of service that must be provided as appropriate. Nothing about regard in Regulation 4, I invite the court to note.
But the primary statute, very strikingly, imposes a duty.
Yes, a substantive duty, not a regard
Give
duty.
breaks from caring.
That's right. And I accept if the distinction is that this is clearly all about short breaks. This is indeed all about short breaks, but there are other duties that aren't, and I'm going to come on to those in a moment. Indeed now, because the next duty that's relevant is here at 29, Section 11 of the Children Act 2004. It's a very wide-ranging duty on local authorities, amongst many others, to make arrangements for ensuring that the functions are discharged, all functions are discharged, having regard to the need to safeguard and promote the welfare of children. And there's then a discussion by reference to the Supreme Court's decision in Zola Mesa about the fact that it imposes a duty on a local authority to have regard to those factors when exercising any function in a way which affects a child. So incredibly broad, it's not just about short breaks, but a have regard duty. Then we have Section 27 of the Children and Families Act. Now this is the part on which this judgment was wrong. It was held to be wrong in Hollow, and then that was approved by the Court of Appeal in Dee and Hackney. So Section 27 does not do what Mrs. Justice Lane said it did. She said driven to the conclusion it did. But what is important, we say, in terms of the approach, is that Section 27 is again a very general duty that requires local authorities to keep under review social care provision and consider the extent to which it's sufficient, and to consult. So not, again, all about short breaks at all. And then finally, but importantly for our purposes, Section 3 of the Local Government Act and the statutory guidance issued under it. At the end of paragraph 31, the judge says it's not immediately obvious that the best value duty is apt to apply to a decision by a local authority to reduce the amount of services a local authority procures from voluntary sector organisations, but I bear in mind the trend exemplified by Zola Mesa. Counsel for the defendant did not suggest that Section 3 did not apply here. And then finally, the actual guidance under Section 3 and what we relied on set out by the judge at paragraph 7, in the middle of that paragraph, authorities should seek to avoid passing on disproportionate reductions by not passing on larger reductions to the voluntary and community sector and small businesses as a whole than they take on. So again, not all about short breaks at all, very general in effect. We can then skip the discussion of the public sector equality duty, because that succeeded for a different reason. In short, officers had misdirected members as to the requirements of the PSCD. The discussion that we need is picked up at paragraph 42, page 240 of the bundle. What the judge said is, conscious of the intense pressures that the decisions were response, time constraints, etc., and I do not, I hope, understate any of these factors. They are, however, not relevant to the legality issue in my judgment. The only question on that issue is whether, in substance, members were given the help they needed on the legal issues, which they had to consider before making a cut to the funding for short breaks. So that's the judge formulating what she considered to be the legality issue. 43, then linking back to the section 149, the public sector equality duty issue, considering the case law, including Morge, on the fact that officers' reports should not be held to too demanding a standard, and the fact that officers are entitled at the bottom of 43 to simplify and make concrete for the purposes of the decision at issue what may be complex legal issues. it may not always help counsellors to give them the text of a statute. A pithy summary, if it's accurate, is often much more use. Then there's the discussion at 44 to 46 of the PSED, and the error was, as I say, at 46, that the officer's summary was not accurate. So that was a very specific error that was made in relation to PSED.
Sorry, where's that?
So at 46, my lord, as I found, members had the factual material that would have enabled them to have due regard to the statutory needs in section 149. However, they were directed to look at that material in a way that did not help them to focus on the right question, but instead told them to focus on an irrelevant or at best only partly relevant question. Had the report only included the text of section 149, it might not have made counsellors' lives easy, but I could have been satisfied they considered the right question. The flaw in the presentation of the material is the repeated use of the formula to which I referred. That way of presenting the equality issues unavoidably suggests the formula is equivalent to or a substitute for the statutory considerations, and it's not. So it was a fact-specific failure by the officers to accurately inform members as to what the PSED required. But we then come to the central paragraphs 47 to 48, which deal with the remainder of the legality issues, so that all these duties to which I just showed before. So my submission on the legality issue was that counsel would breach the various duties imposed by the provisions I relied on. The judge says, I do not consider that that is the real question on this issue. The question rather, as I suggested, is whether members were given the help which they needed to answer the questions posed by those provisions in the context of this case. There's no discussion of what's well known from fewings, that people can comply with the law if it's, as it were, unconsciously, if their minds have been directed to the issues in substance, but it's difficult to reach if members' minds have not been directed to the relevant statutory language and thus the question which they should address. A paraphrase of the statutory test, which includes some but not all relevant matters, is not enough. Express reference to the statutory test, or an accurate paraphrase or summary, as the case may be, ensures a focus on all the factors which Parliament, or in the case of delegated legislation, the executive, has prescribed. And then at 48, there is no trace in the materials given to members of any reference to the express language or to the substance of Regulations 3 and 4 of the 2011 regulations. Pausing there, Regulation 4 is the substantive duty. Or of Section 27.2 of the 2014 Act. Now, that conclusion was wrong. We know that that Act wasn't relevant, but again, a very broad Act. The Council had to consider, for example, in reducing the funding to voluntary sector organisations, whether the provision which remained would in short be sufficient, either simpliciter or so far as was reasonably practical. That's Regulation 4. I do not say that if that was officers' views and it had been conveyed to members, they could not have so concluded. But there's no trace in the report and appendices of any guidance for members about any of the issues posed by Regulations 3 and 4, again, or by Section 27.2. And then there is no reference either to the duty imposed by Section 11 of the 2004 Act, again, the very broad duty in relation to the welfare of children, or the best value guidance, the very broad duty to not pass disproportionate reductions onto voluntary organisations, to which the Council was required to have regard. In other words, members' attention was not drawn to mandatory relevant considerations. I conclude that on those grounds also Decision 1 was unlawful. So we said...
taking 46 to 48 as a whole.
Yes.
The judge seems to me to be saying that if you just include the text of the statute, as it were, in an appendix, you're covered. If you go further than that, you're not.
If you go further than that, you might get it wrong, my lord.
You might get it wrong. So each report to council by the officers should have an appendix, like the appendix to a skeleton argument, saying councillors should be aware of the following relevant provisions: Care Act Section 2, Care Act Section 3, Care Act Section 5. And that would make all the difference.
My lord, yes, in broad terms. I rely on the question, as the judge told me it should be put, which is in paragraph 47. The question, rather as I suggested, is whether members were given the help which they needed to answer the questions posed by those provisions in the context of this case. So simply annexing the legislation without explaining why it's relevant may well not be good enough. But I certainly accept that if there was a short paragraph in Section 8 of the report which brought members' attention to Sections 2, 3 and 5, highlighted that there are duties in relation to prevention and reduction of need, duties in relation to integrating services with the NHS, duties in relation to promoting a range of high quality services and then gave them the text of the legislation, that almost certainly would be good enough. And that's why I started these submissions, my Lord, my Lady, with the submission that we're not asking for anything unduly onerous here. But it's important, because if Parliament has created duties which go to the provision of services of this kind, decisions taken about services ought to be taken with reference to the relevant legislation.
How does this case ultimately help you establish either ground 2 or
It's ground 2, my lady.
But the starting point in this case is that the relevant provisions were mandatory consideration. You've got to persuade us that they were in this case.
My submission, my lady, is that if these provisions were relevant in DAT, then the provisions that I rely on are relevant here. It's precisely the same. And that's exactly, if you look at the skeleton argument below, my lady, how the case was put to the judge. We say that sections 2, 3 and 5 of the Care Act were at least as relevant to the decision the defendant took as, for example, the best value guidance or section 27(2) of the Children and Families Act was to the decision before Mrs. Justice Lane. Now, if Mrs. Justice Lane had only referred to the short breaks duty that my Lord referred to and only referred to the regulations under that duty, I accept that it would be different because those duties were all about the very thing that was being decided. But the legality issue was decided by reference to a much wider section of statutory duties than that. I accept Mrs. Justice Lane doesn't tell us on what basis she accepted that they were relevant duties. And we say that that is because it must be, and therefore on that basis, a matter for the judge. She's decided that these are relevant duties in DAT.
And that's a question of law.
Yes. And that's a question of law for the judge who's presented with an argument that a decision-making process is deficient for want of regard to relevant statutory duties. Now, if we need to put what Mrs. Justice Lane did in DAT within the credence typology, we say these are implied statutory considerations. And we do get some help from DSD, which is the second case that we sent in late. If we could look at that. Well, another well-known judgment, the Warboys case, of course. And the relevant discussion starts at paragraph 136. So 136, citing Henry Findlay, then citing credence, all of this very familiar, of course. Nothing I need to say about any of this, all accepted. But where we do get some help from the Divisional Court, in my respectful submission, is 141, because this is where the court is looking at this category of implied statutory mandatory considerations and distinguishing from the case of obviously material considerations, credence 3 as is often described. And the court says that that distinction has important consequences. If a consideration arises as a matter of necessary imputation because it's compelled by the wording of the statute itself, the decision maker must take it into account, and any failure to do so is without more justiciable in judicial review proceedings. If, on the other hand, the logic of the statute does not compel that conclusion, or in the language of law justice laws, there's no implied lexicon of the matters to be treated as relevant, then it's for the decision maker and not for the court to make the primary judgment as to what should be considered in the circumstances of any given case. The court exercises a secondary judgment framed in broad Wensbury terms if a matter is so obviously immaterial that it would be irrational to ignore it. And Mrs. Justice Lang doesn't put DAT within that context. I want to make that clear. But my submission is that that is in essence what she is doing. She is treating the decision that was before West Berkshire Council, which is whether or not to reduce funding for short break services, as one which implicitly the statutory duties that she considered to be relevant required those duties to be considered. It's a legality question, as she very clearly stated in 5.1. And that, we say, is the best understanding, if it's necessary to put this within the credence typology, as to what which part of that typology applies. So we say, applying that here, sections 2, 3 and 5 necessarily imply that the duties they contain will be considered when decisions of this kind are taken, i.e. decisions to close mental health day centres.
So just so I can understand, are you saying credence 1 or 3?
Credence 1 implied.
1.
One
Credence 1.
implied. If we need to put what Mrs. Justice Lane was doing in DAT within the credence typology, as your lordship's ladyship will see, looking at our skeleton argument and statement of facts and grounds, we relied on DAT. We relied on the approach in DAT as being the basis for the requirement to consider these duties.
Yes, but as
So looking then,
the lady said when giving leave, we have to approach
well
this
indeed,
de novo because then DAT is not binding.
not one, it's quite right, my lord. And so therefore, if we need,
It's been followed by one deputy judge
Yes.
in the admin court. Has anybody else considered it?
not on this point, my lord, but there is another admin court judgment which takes the same approach, which I'll show your lordship very briefly, if I may. So we say in terms of the errors the judge made, going back to the judgment, that he was wrong at paragraph 94 to hold that credence 1 could only arise if a statute expressly or implicitly identifies the existence of a target duty under a different statute as a mandatory relevant consideration. That may well be right as being an example of when credence can arise, but that wasn't the approach in DAT. And very particularly and importantly, we say he was wrong at paragraph 96 of his judgment. If we could turn that up, my lords, my lady.
Yes.
This was, I would submit, urged on him by the respondent wrongly. He was wrong in two important respects. Firstly, to find that all the provisions were have regard duties. We know that Regulation 4 isn't a have regard duty, it's a substantive duty. And he was wrong to find that all the provisions were all about short breaks. Section 11 of the Children Act 2004 and the best value duty and guidance were generally applicable. And so it's because of those errors that the judge was wrong to confine what Mr. Justice Lane was saying in the 80 at 99 the way that he did. Now, the further judgment, my lords, my lady, is SARC, which is at tab 37 of your authorities. Deputy Judge Judge Tyndall, and this came out just after the judgment in our. And in that judgment, Judge Tyndall treated questions posed by Section 5 of the Care Act as credence category 1 considerations. And we pick up the relevant discussion at page 957 of the authorities. This was a case about fees, local authority fees for care home providers. We see the discussion of paragraph 78, turning to ground 2 of the claim, focusing on the considerations of the statute, in particular the market shaping duty in section 5 of the Care Act, expressly or implicitly required to be taken into account.
Right, I feel you're taking this a bit too quickly.
I'm sorry, my lord.
I've not quite got to where you're at.
Apologise.
Can you start again?
Of course. So 957, please, in the authorities.
Yes.
Is paragraph 78 of SARC, dealing with ground 2.
What was an issue in?
So it was a question about whether or not there had been regard to a number of considerations that the claimant relied on. And the judge says that he will focus only on considerations of the statute, in particular the market shaping duty in section 5, expressly or implicitly required to be taken into account. Saying it's often overlooked, that's the correct approach to relevant considerations challenges, referring to Samuel Smith, which both parties before your lordships, your ladyships cite. So none of that is controversial. Paragraph 79, Judge Tyndall sets out the material parts of section 5, which your lordships and ladyships have seen, and then says that the decision's lack of due regard to the actual cost of care and the need to avoid setting arbitrary cost ceilings, so it goes over the page, in the sense in paragraphs of the relevant guidance, are implicitly statutory factors to be taken into account under 5.2 D&E. So that's not relevant to what we rely on, because those are the have regard aspects of section 5. It's the next point. Alternatively, the decision failed to take into account expressly statutory factors. So firstly, the decision failed to take into account the local authority's duty under section 5.1 to promote the efficient and effective operation of a market with a view to ensuring a variety of providers and high quality services. So here, what Judge Tyndall has said is that the substantive duty in section 5.1 was an express statutory consideration. Now, that's not the way that I've understood DAT, as I say, in terms of the DSD judgment. I would submit that the best categorisation of what Justice Lane was doing in DAT was that it's an implied categorisation. But here, Judge Tyndall says that because of the duty to promote the effective operation of a market, that's an express statutory factor under Credence 1.
Why would it be implied? I'm having a conceptual problem here. You're doing something which is making a decision about a service,
Yes.
which is, for want of a better word, not a statutory service. In the sense that it's not something that you're necessarily obliged per se.
That's correct, my lady. It's not.
There's
no express duty.
statute you can find that says you've got to provide a drop-in service.
That's right, my lady.
But local authorities operate within a statutory framework, and your case, as I understand it, is that in doing so, on this particular decision, they had to have regard to these particular statutory
Yes.
provisions. Why isn't that expressed?
Well, it may be that it is, my lady. Oh, and
if it's
that's right, and that's certainly how Judge Tyndall has understood it. It is fair to say that in DAT, Mrs. Justice Lane didn't actually tell me why I was wrong. She simply stated that I was wrong, and that what mattered was whether or not regard had been had to the statutory duties. So, in terms of answering the question that respectfully your ladyship quite fairly asked in granting permission, well, why? I've sought to look at the typology and identify where it may best be understood to fit. Judge Tyndall says it's express. If we look at section 2, my lady, and see that similar to 5.1 in terms of it being a substantive duty, that's 21 in the authorities, a local authority must provide or arrange for the provision of services, etc., which it considers will contribute towards preventing or delaying needs. Our point is straightforward. That's relevant, which is the language that Mrs. Justice Lane used. The existence of that duty is relevant to the decision being taken. Members ought to know that that duty exists in order for them to consider, they're the decision makers, whether or not the services might need to stay open, be closed later, be changed in some way, whether the decision could alter because of the fact that they have a duty to provide services that do these things, and also in particular at 2A, that they have to think about the fact that and it's important that there are services that are already available and the extent to which they can involve or make use of them. So that it's, again, we say not onerous and entirely consistent with good administration, that Mr. Justice Lang has identified that that is the legality question. If it needs to go within the credence typology, then it's either express or implied, because it's clearly not obviously material, we say. That's not the approach she applies. There's no reference to that language of obvious materiality in DAT. So that's the only other judgment we say assists. We say that the position can be summarised as it is in our skeleton at paragraph 39, where a decision may affect the performance of a statutory duty. That decision can be a mandatory relevant consideration in the decision-making process. That's a question of law for the court to decide.
Well, presumably, an authority that has its duties under Section 2 and Section 5 must, separate from consideration of this particular proposal, have looked at the overall position.
My Lord, those duties fall to be performed from time to time as the occasion requires under the Interpretation Act. So there's no specific requirement on the local authority. There's nothing in the legislation that tells them when they must consider these duties. We say that they are generally engaged. And so decisions which affect the pattern of provision in the area for adults with needs for care and support will be likely to engage sections 2 and 5. And in our particular case...
I don't think that's an answer to my question. I mean,
sorry,
my question is, one must assume that the local authority will have considered these duties.
Respectfully, Lord, I'm not sure we do need to assume that, or that there's certainly no evidence of that.
Well, there isn't any evidence that they have.
No, there's no evidence they haven't either.
Yes, and the point is, you don't say that they breached them.
No, my lord. The reason I didn't say that they breached them was because Mr. Justice Lane told me in DAT that that was the wrong question.
Well, let's not worry about.
But
There'd be an awful lot of weight, understandably, because you say it supports you on the first instance decision.
Yes.
But we have to step back a bit.
Of course, my
Look
lord.
at it more broadly. It seems to me these are overarching duties.
They are.
They're not directed at any one particular item of provision. They're looking at the overall provision. And you don't say they breached it. So they must have complied with it. So at some point that has been looked at and considered, and the duty has been complied with. So why do we assume that when we look at this particular decision, that the local authority hasn't already satisfied itself that it's fully conformed with its duties under Section 2 and Section 5 through other provisions?
My lord, the answer to that question, in my respectful submission, is because this proposal, as it was then, may have impacted upon the performance of those duties.
But why? If it's satisfied that other provisions it's made fully satisfy Section 2 and Section 5, then whatever it does here won't impact on that. And you don't say it does.
Well, 2.1, my lord, is not framed as a sufficiency duty. It's framed as a general duty to provide services that do these things. That's how it's framed. And therefore, of course, it's a matter for the local authority subject to rationality as to how much of that service is provided. But we say these were services which did or may impact on the performance of that duty.
Well, they may, but
But Mr. Justice Lang in DAT says that that's enough. Relevant is the phrase that she uses. Are these duties relevant to the decision makers? And again, if we're thinking about this in legality terms, all that's necessary is for the decision makers to be appraised of the existence of the duties and why they may be relevant in order to fulfill the obligation to consider them, which is understood to be part of their legality obligations, not their rationality obligations. So rather than saying you've breached Section 2, we simply say you've not considered Section 2.
But we don't know if they consider this or not, because as it's an overall duty, they may have considered it elsewhere.
They may well have done, my lord. But what we say is that this decision was unlawful in the same way as the Shaw Breaks decision was in DAT, because when members took it, they were not appraised of the existence of these duties, and the judge rightly rejected the alternative case.
They may have looked at it in the decision before.
Well, the judge
And
rejected.
the decision made was, right, we've now fulfilled our Section 2 duties. This is now adequate provision.
Of course, we know nothing about that, my lord, but what we do know is the judge rejected the defendant's case that the members had institutional knowledge of the duties. The judge said if they were required to have regard to them, they didn't. And there's no challenge to that finding. And so therefore, the question for this court is, was he right to say that they weren't required to have regard to them? And we say that the approach in DAT and SCAR, and indeed principle, whether as in express or implied consideration.
Can I just say this? What this amounts to is, in a situation where the way that the matter is put to the decision makers, the members, and the decision itself, neither the way it's put nor the decision itself places the local authority in breach of any of these sections. The suggestion that not referring to the sections in the context of making the decision makes the decision unlawful seems remarkable to me.
My lord, respectfully, it's not remarkable because it's exactly what was done in DAT.
Well, that's what we're trying to decide in part, maybe, whether or not Justice Lane, as she was then, was right about that. So just repeating back,
No, I
that's
understand.
what was done there. It doesn't answer the point. It just restates the question. Was she right?
Indeed, my lord, and my answer to that is yes, she was. Because as a matter of principle, it's entirely consistent with good decision making for it to be a requirement as a matter of law that relevant statutory duties are brought to the
This
attention
is
of
the
the
point. Is
decision
it
maker.
relevant?
Yes.
That's the point, isn't it? If there's no suggestion that the decision would place the authority in breach of a duty,
Yes.
how can it have been relevant for that duty to have been considered? Surely the only circumstances in which it's relevant to consider a duty is if the decision may be performing the duty or breaching the duty, depending on which way it goes.
So, my lord, respectfully, no, because these were services which did, we say, or at least might have done the things that are set out in section 2(1)(a) to D.
Yeah.
The fact that
That's
not
plain.
providing them doesn't breach the duty, doesn't make them irrelevant. They are services that were within the ambit, within the perumbra of the matters that Parliament has set out in section 2. They were preventing or reducing the needs for care and support. And so members ought to know that there was a duty to provide services in that area. It may have affected the outcome of the decision. So that's the answer that I give, and it's consistent.
Well, the local authorities certainly, they were referred to their Care Act, to the Care Act duties, weren't they?
Only the individual duties in relation to eligible need, my lord, repeatedly.
Your point is that the duties are much broader than C3 and 4.
But the Care Act scheme goes well beyond merely meeting eligible
The
need.
one thing you have made clear is that the DAT, front and centre of the way you put your case, was that there were breaches.
Yes.
of constant.
Yes,
That is a distinguishing.
I'm sorry, my lady.
That is a real distinguishing factor.
But my lady, and that's why I rely on it. If you look at the way we've put the case here, it's expressly not put that way because of DAT. I mean, it was effectively binding at first instance, and we've
Wasn't it?
yes,
It's
we
not,
could have said
it's
it
not,
was
it's not binding, but it's highly persuasive.
highly persuasive. Yes, and we say not right in principle as well. So, having had my error corrected, I respectfully adopted the correction. And I can't go beyond that in terms of why the case was put the way it was. It's very, very clear from our pleading and our skeleton argument exactly the way it was put. But we, of course, have to establish that it's correct in principle. And we do. We say it's either a freestanding legality question, or if it falls within the rubric of mandatory relevant considerations as identified in the cases that led to credence, it's either an express or implied one. So there's no error of principle by the judge, and we say it's clearly right, and that our judge was wrong not to follow it, not to understand it properly. We've already explained that he didn't respectfully understand what the statutory provisions were in issue. That's paragraph 96. The next error we rely on, this is paragraph 41 of our skeleton, is the alternative conclusion at paragraph 105 to 106 of the judgment, if we could just look at that. So this is if it was open to us to argue that the defendant was performing duties under the Care Act and was therefore required to have regard to the matters in subsections 2.2 and 5.2. That isn't how I put the case on the appeal, as you've seen. It wasn't how I put the case on the judge from the judge before the judge. But what's we say important about 106 is the suggestion that the provision of the service was avowedly a non-statutory provision made by the defendant and was not regarded by the defendant as being undertaken pursuant to any statutory duty. Well, that can't be right, my lords, my lady, because local authorities are creatures of statute. If it simply means there was no express duty to provide these services, that's not controversial. But in any event, we say that the focus on subsections 2 and 5, subsections 2.2 and 5.2 are red herrings, because they are parasitic on 2.1 and 5.1. They don't stand alone in any event. And then finally, where the judge has erred, we say, is the focus on needs for care and support being merely eligible needs, and that's at the bottom of 106. The judge says it's also of note that the duties under the Care Act to be seen in the context of that Act as a whole. There, needs for care and support are not abstract terms, but are a reference to needs ascertained in relied to an assessment made in accordance with the eligibility criteria set out in the regulations made pursuant to the Act. Well, that's simply wrong, respectfully. those are eligible needs. And that's a very different concept. Needs for care and support means what it says, any need. And once you get into eligibility in section 13, that's when you elevate the need to one to which there is a specific duty to meet. So that's
So where are you reading from, Dan?
in 106, my lord, towards the bottom, about 6 lines up. We say that's an important error because it's similar to the one the defendant made in terms of focusing unduly on the eligible needs point and ignoring the wider Care Act duties that we rely on. So that's ground 2, my lords, my lady, unless I can assist further. Moving on then to ground 3, which is the obvious materiality point. That's paragraph 47 of the skeleton. So here we contend that the judge was correct that statutory duties are capable of being obviously material considerations under Credence 3, but wrong to hold that the Care Act duties were not obviously material in relation to this decision. Our skeleton at paragraph 48 summarises our case on the obvious materiality of each of these duties. If I can just focus again for present purposes on section 2, we say it's plain beyond dispute that a duty to provide services which prevent or delay the development of needs or reduce needs is obviously material, where a local authority is taking a decision about the future of day services for people with mental health needs. And that's my Lord Justice Phillips' point, that actually the judge's own understanding, the defendant's own case as to what the services were doing is sufficient, we say, for our ground 3 obvious materiality purpose. The obvious materiality is even more obvious when section 2.2 expressly focuses on the importance of existing services. In paragraph 50 of our skeleton argument, we say that if we're right about ground 1 and the judge ought to have taken all the evidence in the round, then this ground must also succeed. But I'd wish to emphasise that we win ground 3 even if we are wrong about ground 1 and the judge was entitled to accept the defendant's evidence on impact. And the reason for that is then set out in paragraph 51 onwards in our skeleton. If we look at 109 in the judgment, which is the first substantive paragraph of considering the facts, we say the judge erred by focusing too narrowly on crisis prevention. He says the potential relevance of the duties depends very much on the view taken as to the role performed by the service. The claimant's argument is predicated on their assertion that the service played an important role in preventing the users going into crisis and so operated as protection, etc. And then the force of the claimant's argument is greatly diminished once it's established the defendant was entitled to address the decision on the footing that the service had a limited role and this role did not include crisis prevention. But that's simply wrong. We've already seen the section 2 duty extends well beyond crisis prevention. It concerns preventing, delaying or reducing all needs for care and support. So the judge has misdirected himself here by focusing so much on our case on crisis prevention.
That certainly was your focus on when you were saying that was the point that that was the big point as to what these services would.
Yes, my lord, but that's because that's the extreme end of the spectrum of development of need. So even if the defendant's understanding that the services, as the judge put it in summary, had a more limited role, which didn't amount to crisis prevention, is accepted, that doesn't mean that the services aren't preventing, reducing or delaying the development of some needs, even the needs that are met by the simplest things like making a cup of tea.
I thought your main attack was on the authority's focus on the intended function as opposed to the actual effect of the services. And you say, as I understand it, the benefits or the effects include, pretty importantly, crisis prevention.
We
So
do, my
you're
lady.
not completely sure. I understand why you're sort of playing this point
Be-
down.
because the judge said I'm not going to look at that because I'm applying F and Surrey. I'm only going to take the defendant's case on what the effect of the service is. So I'm assuming for present purposes that we're wrong about ground one and the judge was entitled to do that. We say we still win ground three
I see.
because even on the defendant's, purely on the defendant's evidence as the judge has summarised it, it's obviously material to the decision that there's a duty to prevent, reduce, delay the development of needs more generally. And the judge has wrongly focused on the crisis prevention point. So that's the first error of principle. The second error of principle we say is our skeleton paragraph 52 by reference to the judgment of 111. We say it makes no difference that these were services that were only provided in one part of the county. The relevant duties, sections 2, 3 and 5, all refer generally to the respondent's area. And we'd entirely accept that geographical distribution may be relevant to a rationality challenge, but again, that's not this point. So for the judge to say that the fact that the defendant did not provide services equivalent to the service elsewhere in Devon is significant in terms of obvious materiality, we say again is a conclusion that was not open to him.
Why not?
Because it's still obviously material if you only provide the service in one place, my lord, if it has the effect of preventing or reducing need.
Are you saying that in the 85% of the county that in which there was no such provision, the defendants were in breach of their Care Act duties?
Not at all, my lord, no. What I'm saying is that in deciding whether or not these services ought to be closed, members ought to have been told they had a duty to prevent, reduce, delay the development of need, because it was obviously material to that decision. The fact that they're only provided in certain places is clearly going to be relevant on cost-benefit analysis terms, rationality terms, may well provide a good justification for going ahead anyway. But none of that stops it being obviously material for members to know about the existence of the Section 2 duty. And I keep focusing on Section 2 because for us it's the most obvious, but the same applies for 3 and 5 as well. So we say that is literally an irrelevant consideration, my lord, at this point. Highly relevant, no doubt, to the rationality challenge, but not at all relevant to whether the duties were obviously material. So that's the second error of principle. The third then, skeleton paragraph 55, picks up what's said at 114 about the availability of alternative services. That's towards the bottom of the paragraph. Again, that's not a relevant consideration when deciding whether or not these statutory duties were obviously material. Unless it was to be said that these alternative services would directly replace everything that the Link Centre was doing. Merely the name was going to change, and there's no suggestion of anything to that extent. Again, if it was a rationality challenge, they'd be highly relevant, but it was not. And then an important point of paragraph 56 of our skeleton, the judge, in fact, we say, failed to determine whether Section 5 was obviously material at all. There's no discussion in this part of the judgment of Section 5 at all. That's clearly an error by the judge, as we relied very clearly on 4 duties in front of him, 3 in front of your lordships and your ladyship. If and to the extent he did, I'm asked to look at paragraph 111. So yes, more scope for an argument that section 2, 3 and 5 duties were relevant if the effect of the decision. So there is one, as my little friend rightly says, and one reference to section 5 there, but there's no, we say, substantive determination of that question in anywhere to be found in this part of the judgment. Or if you did, and my little friend points to the one reference to section 5, there's an inadequacy of reasoning. Importantly, paragraph 57 of the skeleton, the judge correctly found that there had not been any regard to these duties. So if we're right that they were obviously material, the claim for judicial review would necessarily have been allowed. And finally, as per paragraph 58 of our skeleton, we don't accept that the question of obvious materiality is a finding of fact. It's a mixed question of fact and law, with which this court can interfere on the usual basis, being that it was wrong, with a sense of being based on misdirections, as we set out, and ultimately not being open to the judge. So that's our ground 3, and we do say that that is, of course, the most straightforward ground, because even on the judge's understanding of the factual matrix, we say these statutory duties plainly were obviously material, particularly section 2, but also the integration duty in section 3 and the market shaping duty in section 5. and the reasons the judge gave as to why they were not are patently wrong, in my respectful submission. So very finally, my lords, my lady, I need to deal briefly with the respondent's notice and the two alternative bases. First of all, the respondent submits the judge was wrong to find that the statutory duties are capable of being obviously material considerations. And the short answer to this point is that there's no authority supporting the respondent's position here. If we look at paragraphs 62 to 74 of the respondent's skeleton argument, there's literally no authority cited in support of that proposition. The only case that the respondent seeks to rely on is the AA case, which is cited in their skeleton at paragraph 68, and that takes the respondent nowhere. The principle that a statutory duty can be an obviously material consideration doesn't elevate a target duty into a specifically enforceable duty in substance. Again, to reiterate, all the public body would need to do is to direct itself to the existence of the duty and consider its implications for a proposed decision for the performance of the duty. They wouldn't need to comply with it substantively in any individual case. Of course, if the respondent is correct, then DAT and SARP have been wrongly decided. They may have been, that's of course a matter for your lordships and your ladyship, but it's a relevant factor. And we say there's no good reason why statutory duties should not at least be potentially obviously material considerations. The respondent in paragraph 69 of its skeleton sets up a straw man, we say. The threshold for obvious materiality is set high, and officers would only need to consider duties which directly related to the proposal. So, for example, looking at the DAT duties, we would submit that the best value statutory duty and guidance wasn't obviously material to the decision in DAT, but the duties in the schedule to the Children Act and the regulations were. So if Mr. Justice Lane had been approaching it on obvious materiality, we say that the error would have been confined to those provisions that were indeed all about short breaks. We say that's not unduly onerous, and the planning cases on which the respondent relies, paragraph 70 to 71, take it nowhere. Could I briefly turn up our supplemental skeleton on this point, which is at 301 in the core bundle? So at paragraph 5 onwards, we cite a number of cases where various kinds of legal obligations have been treated as relevant considerations, which could become mandatory under the obvious materiality principle. I'm just going to turn up two of those, if I may. The first of all is Friends of the Earth, the Supreme Court, paragraph tab 28 of the authorities. And the relevant discussion begins at 599 in the authorities bundle. This is described as being the section 10 ground, you can see in the middle of page 221 of the report. And section 10 of the Act applies the Secretary of State's function in promulgating the NPS as the objective of contributing to the achievement of sustainable development. And then section 10.3a provides the Secretary of State must in particular have regard to the desirability of mitigating and adapting to climate change. That's the bottom of 115. 116 is the statement of principles. Again, none of that is in dispute. So I go forward, if I may please, to 122. The Divisional Court and the Court of Appeal held that the Paris Agreement fell within the third category identified in Fewing, insofar as it is an international treaty which has not been incorporated into domestic law. This is correct. So that we have Supreme Court authority that an unincorporated international treaty can be a credence 3 consideration, as in one that can be capable of being mandatory if it's obviously material. However, the UK's obligations under the relevant treaty, Paris Agreement, were given effect in domestic law, and the Supreme Court went on to hold that the duties under the Act clearly were taken into account when the Secretary of State decided to issue the AMPS. So it didn't matter that essentially the priority was given to the domestic legislation. If we then also, my lords and ladies, look at Packham, which is 26 in the authorities, Court of Appeal, again concerned with the Paris Agreement. And we pick up, please, page 544 of the authorities for ground 3B. Did the government fail properly to consider the implications of the Paris Agreement to the Climate Change Act? And again, there's familiar, well, first of all, of course, 83, the relevant provisions are set out. Then we see the way the argument was put before the Court of Appeal at paragraph 91. The review panel and the government failed to identify and assess how the substantial carbon emissions, etc., would affect the UK's legal commitments under the Paris Agreement. And in the middle of the paragraph, again, this is still the case that was being put, the Paris Agreement was obviously material to this decision in the same way as it had been to the designation of the ANPS in Plan B Earth, which of course was the Court of Appeal in Friends of the Earth. And then we move forward over the page, we see that argument was rejected. And the discussion that's relevant for our purposes is actually, I'm afraid, that's after the sidelining. It's really 100 to 102 we say that's particularly relevant. We do not accept Mr. Wolf's submission that the circumstances here are comparable to those in the Heathrow Plan B Earth. 101, it should be remembered that in Plan B Earth, relief was granted not merely on a single ground, but to remedy 4 distinct though related errors of law. And it's the second that's relevant for our purposes over the page. Towards the middle of that paragraph, secondly, that the designation of the ANPS was in any event unlawful because the Secretary of State acted in breach of Section 10.3 of the Planning Act, which required him in particular to have regard to the desirability of mitigating and adapting to climate change, in that he failed to have regard, indeed deliberately did not have regard, to the Paris Agreement as an obviously material consideration. And then at 102, the Court's conclusion on the Section 10.3a issue, holding that in the circumstances the Paris Agreement as an unincorporated international obligation is so obviously material that it had to be taken into account in discharging the explicit requirement in the provision of that statute, did not depend on the government's commitment to the Paris Agreement necessarily having the status of government policy within the reach of Section 5.8. It simply depended, and this is what we rely on that unincorporated international obligation with its clear significance for the UK's responsibilities in mitigating and adapting to climate change, qualifying in the context of the provision in Section 10.3a as an obviously material consideration. It was not submitted nor concluded that as an unincorporated international obligation, the Paris Agreement was automatically an obviously material consideration in any decision where the implications of infrastructure development were an issue, but only that in principle it could be. And given the specific statutory context provided for by 10.3, in that case it was. So in short, my lords, my lady, what the two cases I've shown the court show is that unincorporated international conventions are capable of being mandatory relevant considerations under Credence 3. And we say that if that's the case for unincorporated international conventions, there's absolutely no reason why that shouldn't also be the case for potentially relevant domestic statutory provisions. That's the submissions I wanted to make on issue 1 from the respondent's notice. And then finally, the second issue, the respondent seeks to overturn the judge's conclusion on section 31(2)(a). We addressed that at paragraph 18 of our supplementary skeleton. We said the judge correctly directed himself to the statutory test here, and he reached a conclusion that was open to him on the facts. And we emphasise that...
Well, that must be evaluative, surely.
Yes, it is,
Yeah.
entirely,
Yeah.
my lord. We absolutely agree. And that's what we say at paragraph 20 of our skeleton, that it's an evaluative judgment which should be respected. Of course, it could be wrong, but we say it's not wrong. And we do also emphasise that the case of Greenfields shows that the threshold remains high.
Yeah.
Given the time, my lords, my lady, and given that this is a point for the respondent, I perhaps could leave it there and deal with anything else on that point in reply, unless I can help further on section 31(2)(a) at this stage. Yeah. May I just turn my back and check? Unless I can assist further, my lord.
Can I just ask one thing?
Of course.
In terms of what the authority should have done,
Yes.
and what they could have done,
Yes.
if they had followed, I think your suggestion of what they should have done, they would have outlined for the members
Yes.
the statutory duties in sections 2, 3, and 5, and that's all you say they need to do.
I would go beyond that, my lord, and say they would have needed to explain in rational terms why they were relevant or potential.
Okay, but also, presumably, you would have to accept that it would have been lawful for them to have said, you're satisfied that none of these duties would be breached if this proposal is accepted.
Yes, that could have been their recommendation. And then it's a matter for the members
They
whether...
but they would have been able to, no, it wouldn't have been a recommendation, they could have stated that they were satisfied none of those duties would be breached.
Yes, my lord, I would accept that. What we would, of course, we're speculating, and it's difficult to speculate. If the officers had said, it may be said that these are relevant duties, but we don't think they're relevant at all, then we would potentially have a rationality challenge to the report and to the decision on that basis. But all I need to do in my respectful submission is persuade the court that the absence of any reference to them makes the decision unlawful.
Well, you would say that they would have to say they were relevant.
Yes.
But they would be permitted to say that they weren't breached.
Yes, because we go on to say that we provide other services that, for example, prevent or reduce needs. Yeah. But what would the difference it would make, my lord, and this perhaps does come back to section 31.2, is that members would then have been proceeding on a properly informed basis as to what their full suite of care activities were, and might have thought, actually, given the duty to, for example, focus on the value of existing services, we're not satisfied that these
But
services...
this isn't the basis upon which the judge considers section 31.2a, is it?
So if we just look at that, my lord, I apologise, I haven't got that to hand. That will be necessary at the end. So paragraph 143, oh sorry, 134. No, sorry, 139, my lord, so I suppose page 143, paragraph 139. And of course this is obiter because his primary conclusion is that...
That's the nature of respondent's notice, isn't it?
Yes, my lord. But what he says is that if I'd found the statutory provisions on which the claimants relied were obviously material considerations, I would not have accepted the defendant's argument. The outcome would have been substantially the same if they had been considered. Although the factual matrix would remain unaltered, it cannot be said that consideration of the provisions would have made no difference, given that the consideration would have been made on the basis that they were material considerations. So it's put very shortly, my lord, but essentially it is saying, with respect to what I'm saying, which is that we don't know what the members would have decided if.
But what he doesn't take into account is that to reflect the position that you're advancing, they would have said these are relevant, but they wouldn't be breached.
My lord, respectfully, we don't know what they would have said. I accept that it would have been.
No, we have to assume that they would have said. We have to assume that they would have said, on this case, what your case is, which is that they are relevant but not breached.
My lord, again, with greatest respect, I don't accept that we have to assume what they would have said. We don't know what the report would have said.
That must be your case, isn't it? That they should have said. They should have said what the correct legal position is. You say.
Our case is that they had to say something about the statutory duties. They had to bring their existence to the attention of the members and explain why they were relevant. What they then went on to do is speculation, and that's respectfully precisely why section 31.2a imposes such a high threshold, because we just don't know. I apologise if that's not helpful, my lord, but I
understand what you say. I just wonder whether it's right to say that one has to postulate that the members would have been told about duties which you accept they wouldn't be breaching.
And that perhaps, my lord, goes back to the fundamental point, which is, am I right that relevant duties fall to be considered?
Yes. But it seems to me, forgive me, I think all I'm saying is I can't see how we can, the counterfactual, it seems to me, on the basis of what you're postulating, would be that they would have to be told that there were relevant duties, but that they wouldn't be breached. To do otherwise would be to give the members a misleading advice, wouldn't it?
My lord, perhaps that's really a question for my learned friend. I don't duck the question, but I do think that section 31.2a needs to be put forward by the local authority, and I do keep seek to keep the courts in mind on the fact that the threshold is set very high. precisely because this court has repeatedly stated we shouldn't be speculating about what would have happened if the decision had been made lawfully. And so the minimum we say is they would have had to bring them the duties to their attention, explain why they were relevant, and my submission is straightforward. That might have made a difference.
If we're talking about whether if the decision had been made lawfully,
Yes.
so we're having to look at what it would have meant to have been made lawful.
What were the minimum requirements of lawful decision making?
Yes.
And I respectfully demur from the suggestion that they would have had to have been told that there would have been no breach. It could be a matter for the members what the implications of the duty was.
Yeah.
Unless I can assist further, my lords, I'm very grateful.
Thank you very
Lady.
much. Miss Layden? Right, well, that's good timing. Thank you. We'll resume at 2 o'clock.